Hello friends, in the series on the income tax cases today, we will discuss a very important case of Cargo Motors Private Limited versus Deputy Commissioner of Income Tax. This case has been reported in 453 ITR at page number 554. The matter has been decided by Delhi High Court and the date of the judgment is 7th October 2022. Friends, as all we are aware that there is section 14A, which is a charging section, and this section gives the power to the department to disallow the expenses incurred by the assessee for earning the exempt income. What was happening that the assessees were earning exempt income and they were claiming this exempt income while filing their return of income, but they were not disallowing the expenses which were incurred for earning this exempt income. So for this purpose, some state jacket formula was brought into the statute, according to which if the assessee does not disallow the expenses which are incurred for earning the exempt income, then there is rule 8D read with section 14A, which says that the disallowance of 0.5% of the average investment which is eligible for earning the exempt income can be done by the assessing officer. But the rule is that if the assessee suo motu disallows some expenses, then the assessing officer cannot make the addition by this state jacket formula of 0.5% of the average investment without disregarding the disallowances made by the assessee. Meaning thereby that the assessing officer has to demonstrate that whatever the disallowance has been done by the assessee, that is not sufficient, and that is why the assessing officer is applying the formula of 0.5% of the average investment. But we all have seen in our assessments that the department is very bluntly applying this formula. In this case of section 14A disallowance read with rule 8D, there is one thing more important, that when the assessing officer is going to disallow this 0.5% of the average investment, then this investment should be related only to that investment which is responsible for earning the exempt income. Although there is the circular of Central Board of Direct Taxes dated 11th February 2014, which says that even if the exempt income is not earned, then the disallowance under section 14A can be done. But as all we know that circular cannot override the rules and the enactment, that is section 14A. That is a different situation that in the present statute there is amendment that even if the exempt income is not earned, then section 14A can be applied. Earlier, the courts were giving relief to the assessee that if the exempt income is not earned, section 14A cannot be applied. That is a different scene. But in this case, when the assessing officer has applied section 14A rule 8D, then the assessing officer took all the investments, whether they were yielding the exempt income or not. So when this matter traveled to the High Court said that only those investments can be taken which are yielding the exempt income. Meaning thereby that the charging section 14A read with rule 8D cannot be applied straightforward, and the assessing officer has to demonstrate that the assessee has incurred some administrative expenditure, and first of all the assessing officer has to demonstrate that whatever the disallowance has been done by the assessee is not sufficient. So in nutshell, it was the point of the High Court that in calculating the disallowance under section 14A, only those investments should be considered which are yielding the exempt income. Friends, this case is very important because a lot of litigation is there on section 14A. Whenever the assessing officer finds any investment into the books of accounts, whether they are yielding exempt income or not, they make the addition. So this case is worth reading and is very important. At the end of this video, once again I am repeating the name of the case. The name of the case is Cargo Motors Private Limited versus Deputy Commissioner of Income Tax, and this case has been reported in 453 ITR at page number 554, and the matter has been decided by Delhi High Court, and the date of the judgment is 7th October 2022. Thank you, friends.